This is a test. Court of Appeals 7th Circuit. This is a test. This is a test for the Court of Appeals 7th Circuit. Test, 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 test.
Good morning, ladies and gentlemen. Our first case for argument this morning is Doe against Burke. Ms. Chenevert.
Good morning, and may it please the court. I'm Assistant Attorney General Caitlin Chenevert, and I represent the defendants' appellants, cross appellees. In May of this year, this court issued its decision in Walton v. Niels.
Before we get into the merits of this, I'm wondering why the briefs all use Jane Doe as the name of the plaintiff when her real name was freely used in public at the trial.
I believe that on appeal before this court, plaintiff's counsel filed a motion to proceed anonymously.
Yeah, but I'm asking for reasons, right? This name is already in the public domain. Why should we proceed as if it were not?
Your Honor, standing here at this moment, I don't believe that I have an answer to that question. I would be happy to provide a supplemental Rule 28.
Well, if we need supplemental filings, we will ask for them. But the normal understanding is that once something is in the public, it's in the public, and we don't pretend otherwise.
I'd be happy to submit a Rule 28J letter or supplemental briefing if this court would.
As I say, if we require a supplemental briefing, we will let you know.
In this court's decision in Walton v. Niels, which was issued in May of this year, it affirmed the district court's grant of summary judgment to a defendant prison official who an inmate had claimed had engaged in a consensual sexual relationship with him in violation of the Eighth Amendment. Walton held that evidence of an inmate's consent is relevant in an Eighth Amendment custodial sexual assault case. As a result, consent must also be relevant in Eighth Amendment failure to protect cases involving the same conduct. Walton has an effect on this appeal in two important respects. First, because Walton establishes that evidence of an inmate's consent is relevant in Eighth Amendment custodial sexual assault cases, the district court's exclusion of that evidence based on its conclusion that evidence of consent is never legally relevant was incorrect, warranting a remand for a new trial. Second, Walton supported...
I'm not sure that's enough, right? The critical question, it seems at least to me, is whether the record would permit a reasonable jury to find that the plaintiff consented, in fact. Now, would it so permit?
Certainly, yes, Your Honor. The record evidence would allow a jury to reach that conclusion.
Certainly.
Based on one hearsay shred in the Hicks report?
No, Your Honor.
Is there other evidence?
It's not solely based on that evidence, Your Honor.
What else is there?
So there was also evidence in August of 2017 when ISP was conducting an investigation into the matter. Doe was interviewed by ISP at that point and was asked about the relationship with McLeod, and during that time she at first initially stated that it was a consensual relationship. So there certainly is evidence that could be introduced to the jury that would allow the jury to assess whether or not this was actually a consensual relationship. Separate and aside from that particular aspect of this case, though, Walton established that a defendant's subjective belief remains relevant. And so here, Sexton received the report in the Hicks report that there was a possible relationship between Doe and McLeod, and based on the information in that report, his testimony during his offer of proof was that he believed that the relationship was consensual, and he also testified that belief influenced the level of danger that he believed that Doe was in, as well as how it was that he conducted his investigation. So had the jury heard all of the evidence as to Sexton's all of the information contained in the Hicks report, not just the redacted portions, but as well as the portions that led Sexton to believe that it was a consensual relationship, and then allowing him to explain his belief as to the level of harm that he believed Doe was in, the jury could have then fully and completely assessed whether that belief was credible, and then ultimately then whether the actions taken by defendants rose to the high level of deliberate indifference. And so for that basis, the district court's exclusion of that evidence, based solely on the belief that as a matter of law under the Eighth Amendment, that evidence could not be admitted, that was incorrect. And again, so a new trial is warranted to allow that evidence to be introduced to the jury. I would also note that in the reply brief, Doe argues that even if it is relevant, it would have to be excluded under Rule 403, but that balancing analysis would have to weigh still in favor of allowing this evidence to be entered. Again, as part of Doe's claim against Burke and Sexton here, she has to establish the subjective element of the Eighth Amendment claim, meaning that they actually perceived a serious risk of harm to her. And so their ability to defend against that claim rests on their ability to explain what they knew and what they believed that meant as far as the risk of harm to her. So there's...
I would have thought your strongest use of that evidence might have to do with the issue of punitive damages.
It's certainly relevant in that respect as well.
Because, I mean, this looks to me like shreds of evidence of consent in an inherently coercive situation. But when a plaintiff seeks punitive damages, a whole lot of other mitigating circumstances become relevant.
Correct, Your Honor, and as we argued in our brief, the consent evidence is relevant not only to liability, but also to this issue of damages, and particularly, as you noted, to the issue of punitive damages, and whether the jury may assess that no punitive damages were warranted here.
We can agree, can't we, that sexual relationships with an inmate are criminal whether there's consent or not, correct?
Correct, yes.
And I'm wondering how your theory would play out, for example, in a school setting where a teacher or coach has sexual relationship, maybe completely consensually, but with a teenager who cannot legally give consent. Does the how does the evidence of consent being relevant play out in that kind of a case?
In that sort of a situation, Your Honor, that may be closer to, for example, the Doe versus Oberweis case that the district court relied on here, where there was a legal reason that I believe in that case it was an employee could not consent with the employer. And in that sort of a situation, then perhaps it is more appropriate to analyze state or federal statutes that would prohibit consent and then import that information into the particular...
Why is this different?
This is different because, as explained by this court in Walton, in the Eighth Amendment context, while criminal state and federal statutes and criminal statutes may be relevant, and of course in Walton this court analyzed all of those statutes, but ultimately determined that for purposes of the Eighth Amendment, it could not create a per se rule that consent was never relevant.
But you'd agree with me that the evidence of consent in Walton was light years ahead of the evidence of consent here?
It was certainly different, that's correct. Yes. But again, even if the evidence was different, it was still a question that defendants raised this question. It had evidence to state that Sexton believed that this was a consensual relationship. There's also clear evidence, and as far as I am aware, undisputed evidence that as soon as upon learning that information, Sexton reported that information to his superiors and was told to gather more information. So certainly here, there was evidence that defendants had wanted to present to the jury that there was a belief that this was a consensual relationship, and allow the jury to assess that evidence and determine whether it was credible, and if so, whether that could go to liability or to potential damages.
So do you think a jury should be instructed that consent is a defense here for McLeod, for Sexton, and for Burke?
As to McLeod, McLeod was defaulted and liability was entered as to him.
Assume he shows up. Assume he shows up for this whole case. he's entitled to put on a consent defense, you think, under Walton?
Well, certainly Walton left open that possibility. The court ultimately declined to adopt any strict balancing test or rule, balancing rule analysis. The court suggested that perhaps the rebuttable presumption approach that has been adopted by other circuits may be the best approach here. So certainly that's a possibility still that under whatever approach the court were to adopt, that the defendant or the state could show up and say, this was the information that we had, this was the belief that we had as to consent in this case. I would note, in addition and separately from the request for a new trial, as we argued in our below and in our briefs, in the alternative, Sexton and Burke would be entitled to judgment as a matter of law under Rule 50 as to qualified immunity, because of the fact that in 2025 it was not clearly established that consent could never be relevant in the Eighth Amendment context in sexual.
The problem, counsel, that I have with that argument is that you seem to be, the question is not relevance there, but at least as I understand the question of qualified immunity, it is whether under the circumstances the defendant faced, the defendant's response was contrary to clearly established constitutional law. And that's where the factual differences between Walton in this case take on, at least in my mind, a great deal of significance. Maybe you could address that.
Certainly. I think even if the question ultimately was, did Sexton credibly believe that Doe had consented here, that could still be a question presented to the jury, allow the jury to answer that question, perhaps in a special interrogatory, and depending on what the answer to that question is.
I'm lost. What do you refer to as that question?
Whether
the defendants believed something in good faith?
Or whether that belief was credible.
But the problem is, as Judge Hamilton just said, under the Supreme Court's test, qualified immunity does not turn on the subjective beliefs of any party. It turns on the state of the law. It used to be called, back in the early 1980s, good faith immunity. That's pretty much how you're arguing. And then the Supreme Court said in 1987 that good faith has absolutely nothing to do with it. It's only a matter about what does the law provide. So why would their subjective beliefs matter?
Well, certainly, Your Honor, in the context of qualified immunity, the general question of qualified immunity as a matter of law, but to the extent there are questions of fact that are relevant to that analysis at all, that the question of the credibility of Sexton.
Yes, but why would their subjective beliefs matter? We can have a debate about how they would be proved if they matter. But why would they matter under the Supreme Court's prevailing test for qualified immunity?
It would not matter in the sense that it would not be clearly established that Sexton or Burke here could not have considered consent at all in assessing the risk of the potential risk of harm to Doe. I do see that I'm getting into my rebuttal time. If the court has any further questions.
I do, because I was trying to figure out, I mean, a prison official who gets this kind of a report has got a tough job, right? Tough decision to make, in the sense that the report may or may not be accurate, may or may not be credible, and if we go the direction you want us to go, it's always going to be possible that the relationship may turn out to have been consensual, at least to some degree, right?
I can't speak to every scenario, but I certainly could see that would be a possibility, yes.
And so, and it's also always going to be a crime. So I'm struggling with it, frankly, as to how you get to qualified immunity here.
Well, again, even if this court were were to decide that qualified immunity was not proper here, at the very least, a new trial would be warranted to allow the defendants to introduce this evidence of consent. And if I may reserve the rest of my time for rebuttal.
Mm-hmm. Certainly, counsel.
Thank you.
Ms. Kramer.
Yes. Good morning, Your Honors, and may it please the court. Britt Kramer on behalf of Plaintiff Appellee Jane Doe. I actually want to start where you started, Judge Easterbrook, as to why the appellants sought to introduce consent in this trial.
No, I would like you to start where I started, which is, why are you referring to the plaintiff as Jane Doe when her real name is in the public record? And if you look at a transcript of the trial, the name is used over and over and over. How can we pretend that something is a secret when it's public?
You need not. This was done by agreement.
So we should use the real name.
Feel free.
Thank you.
Speaking to the consent evidence that appellants sought to introduce at trial, I was surprised to hear the government's position today is one they have never raised before, that the consent evidence could have gone to the question of whether Ms. Doe, Andrea Nielsen, actually consented to the sexual abuse she endured while incarcerated at Logan Prison. I'm referring right now to the government's brief, their reply brief. It's document number 78 on this appeal, page 19. The government states, the district court's decision to grant Doe's motion in limine prevented Burke and Sexton from presenting evidence that they believed that Doe had consented to a sexual relationship. That evidence was relevant to Burke and Sexton's defense because it went to their subjective knowledge. Lack of consent was stipulated in this case. It was admitted by the abuser. That admission was never challenged at any point at trial or since. So to be very clear, there is no basis on this record or otherwise that the jury could have concluded there was actual consent here. Critical to recall. Additionally, there are multiple grounds that don't even turn on consent whatsoever for the jury's verdict to be upheld and sustained. At trial, there was ample evidence that Logan was a dangerous and toxic culture for inmates who were incarcerated there, like my client Doe.
I wouldn't have any trouble with the evidence if the defendants had been permitted to introduce evidence of consent. But the district judge said, that's completely irrelevant. I will not receive any such evidence. We have to decide, well, I don't even want to put it that way. Given our later decision in Walton, that decision was the district judge's decision was mistaken. So we are back to the question whether the record as a whole, think of this as a summary judgment record, would have permitted a reasonable jury to find consent, not whether the trial record required a finding of consent. So would you just expand your take to the whole record rather than the trial record?
I do, Your Honor. I'm including the offers of proof because respectfully I disagree. There was ample evidence before the Hicks report. The only so-called evidence of consent that has ever been pointed to by the appellants as actually evidencing consent, which again, uncontested, there was no actual consent here. The only evidence of consent that appellants had at the time they made any decision in this case came in December 2016 at the time of the Hicks report. The trial record showed deliberate indifference to my client's constitutional right to be free of sexual assault well before that date. I'll give you some of that evidence now if you would like me to go through it in the record. It is undisputed, testified to by the defendants, that Logan had a toxic culture where staff did not treat their female inmates with respect. Defendant Sexton testified that many members of Logan's staff, including himself and the female investigator charged with investigating claims of sexual abuse, were themselves having inappropriate, sexually charged relationships with others on site at that prison and during the workday. They testified that sexual harassment ran rampant at Logan and was tolerated. Both defendants, Burke and Sexton, admitted, conceded, undisputed, that Logan had known blind spots with no surveillance, including no cameras, and that included the vocational building where my client's assault actually occurred. They noted that these blind spots were quote unquote hot spots for sexual abuse. They also acknowledged there would be many reasons why prisoners at Logan might not feel that they could report non-consensual sexual contact given these circumstances, and they conceded that Logan had higher rates of sexual assault and specifically staff on inmate abuse than other IDOC facilities. On this record, there's no dispute of deliberate indifference before the Hicks report. And by the way, these facts remained true even after there was a credible and detailed report of my client's ongoing abuse in a known sexual hotspot by defendant McLeod. So those conditions were present at all points before the report, all points after, and they were not remedied. Failure to act is enough to prove deliberate indifference. Supreme Court established that in the Farmer case of 1994, and there's ample evidence of failure to act here. But I would actually like to focus on the ways that defendants' actions actually increased the risk of sexual assault at Logan Prison. Burke and Sexton both testified and admitted that they knew they were responsible, given their roles as the warden and the lead investigator at the prison, to set an example.
Have you moved on from the evidence about actual consent?
There is no evidence of actual consent.
Okay. I understand your position.
It's also the government's position.
Could I ask you, Ms. Kramer, you all have put together obviously a powerful case and got this striking verdict, I'll put it that way. And I understood that the damages theory that you put on evidence that would allow the jury to find liability from the beginning and not just after the Hicks report came in, right?
That's correct, Your Honor.
But those are, in essence, two somewhat different theories of damages. And one of the things that troubles me is the way that the damages issue was presented to the jury in the verdict form as just, in essence, all or nothing on compensatory damages for the entire stretch of McLeod's abuse of and rapes of your client. And what I'm troubled by, it seems to me that a jury might reasonably have said no liability up for, at least for Doe and Burke, up to the Hicks report, but certainly after that report. But that possibility doesn't seem to have been accounted for in the way the jury was asked the questions. What am I missing?
I appreciate the question, Judge Hamilton. The damages that are the compensatory damages here go to compensating my client for her injury. And that injury is indivisible. It is the trauma that she suffered while being at Logan, both before and after the Hicks report, as a result of the sexual abuse that she was not protected from.
We would not treat this as indivisible, for example, for criminal law purposes, right? We don't, if there are multiple, for example, sexual attacks or non-sexual, for that matter, attacks on a human being, those are punished separately, counted separately, for example, for guideline purposes. I guess I'm having trouble understanding why this would necessarily be indivisible, such that, for example, Doe and Burke are necessarily liable for harm that McLeod inflicted in the several months before the Hicks report was provided.
Your point is well taken as to criminal circumstances, but not for tort circumstances, which this is a tort claim. And in those circumstances, you take the victim as you find her. It's an eggshell plaintiff problem. And so what we have here is we had a individual, my client, who had already suffered significant trauma. And I should hasten to say, you don't need to reach this question, because as long as the jury's verdict can be sustained on any theory in the record, you must affirm. And I believe, and I would assert, that the pre-Hicks report information, that self is sufficient. But to address your question, in damages, in calculating damages, you take the victim as you find her, you take the injured as you find her, and you look at what the resulting harm was. Here, even if they first were put on notice by the Hicks report, which I submit is not true, but even if you take that as your assumption, this was an already deeply traumatized person who they then failed to prevent from being re-traumatized, deepening that injury, which is an indivisible injury. And Dr. Burgess, who was one of our experts at trial, actually testified to this during the appellant's offer of proof. She explained that it is like if you re-break your ankle, that break is deeper. We find that you're still liable for breaking the ankle in tort law under that circumstance, and you're liable for the harms that actually result from that deeper break. So too here. I'll also note that the appellant's concern about the jury verdict is unsupported as well for several reasons, but their complaint is actually about whether there needed to be a date to establish liability. And I would submit that there didn't need to be a date under the indivisible injury facts that were established. But in addition, assuming that there had been concern about the toxic environment at Logan, yet that is a claim that didn't put the appellants on notice until the Hicks report, that toxic environment itself continued unabated after they got that report, and they continued to do nothing about it. And what the undisputed evidence trial established, defendant Sexton testified to this. There is a special hellish kind of injury for living under the threat of sexual abuse. That injury was present at all times, and that injury persisted after the Hicks report, both due to the environment in that prison and due to their decision to use my client as bait instead of taking immediate action to remove her from those dangerous conditions.
Ms. Kramer, could you address my concerns about the way that defendants' beliefs that there may have been some issue of consent here would be relevant to punitive damages?
I can, Your Honor. So first of all, I would note that there is no evidence in the record or on appeal at any time, including in every offer of proof, including in the briefing, that defendant Burke ever formed any subjective belief about consent. So there is no evidence there to show that she had any state of mind that would make her less culpable for her decisions. And in fact, defendant Burke recognized at trial that she had an independent obligation to intervene to defendant Sexton's plan to hold my client out as bait. It was her duty to uphold the law, and she knew this plan could re-victimize my client, and she approved it anyway. So as to punitive damages for defendant Burke, there's literally no argument available. As to defendant Sexton, his arguments about consent are not that he actually believed that she consented. His argument, and again, that's not a disputed issue in this case. His arguments about consent go to his assertion that his subjective belief about consent somehow altered the duty he had to investigate portions of what he was hearing. Now, this is a really important point, Your Honor, and so I want to direct you to the trial record 269 at page 129. And I'd encourage you all to go read it, because defendant Sexton stated very clearly, question, and this was under questioning from his counsel, question, does the fact that it appeared to be an agreed upon relationship affect your evaluation of the emergency nature of the situation? Answer, no. Question, but did it affect whether or not you thought she was in danger of being harmed? When you allowed them to meet so that you could catch them, did that affect whether or not you thought she was in danger of being harmed? Answer, no.
This is from the offer of proof?
Yes, sir. So the evidence that would have been in the record about consent would not have shown a less culpable state of mind, and it was absolutely appropriate for the trial court to exclude it. You have to have an abuse of discretion standard for an exclusion of evidence. Here, that exclusion was entirely appropriate. They were hoping to confuse the issues before the jury as to stipulated consent, as appellants are trying to do even now here today, and that would be far more prejudicial to my client than probative. It was well within the court's discretion to make that conclusion, and you may affirm that conclusion on any basis available on this record. Thank you.
Ms. Chenevert, you have 30 seconds.
Very briefly, Your Honors, as to counsel's argument that consent evidence would have no relevance as to Burke and punitive damages, that is incorrect. The evidence at trial was that Sexton immediately reported the information to his superiors, including Burke, and based on that information, he was instructed to gather more information, which would allow a jury to infer that there was similarly a belief by Burke that this was a consensual relationship. I see that I'm out of time. For these reasons, we ask this court vacate. Thank you.
Thank you, counsel. The case is taken under advisement. Court will hear argument next in Hillman against the Toro Company. Mr. Crowley.
Good morning, Your Honor. Good morning. My name is Stephen Crowley, and I represent Rebecca and Jennifer Hillman and their minor daughter. We're here on this diversity personal injury products liability case this morning to ask this court to reverse 4 decisions that were made on September 30th, 2024. On that date, the district court entertained 3 motions to exclude our liability experts filed by Toro, and 1 motion for summary judgment filed by Toro. In about a 30-page opinion, the court excluded all 3 liability experts, all of their opinions, and then granted summary judgment based on the fact that we no longer had any liability testimony from experts. An understanding of this case and the importance of the Daubert analysis under Rule 702.
You do realize that Rule 702 has been amended twice since Daubert to replace the Supreme Court standard with a new standard in the rule. Shouldn't we just refer to Rule 702?
Yes, we could. An understanding of why we believe the court should reverse all 4 orders requires a brief review of facts.
There's only one order before us, counsel.
Pardon me, Your Honor?
There's only one order before us. It's the order dismissing and granting summary judgment. There are different reasons for the order, but there's just one order.
Thank you, Your Honor.
Mr. Crowley, obviously there are a lot of issues. Time is limited. It would be helpful to me if you could focus in, and I hope the defense will as well, on Mr. Berry's report, and specifically his opinion on the lack of an independent brake in the product here. It's at pages 6 to 10 of his report. And what I was looking for was someplace where the district judge engaged with that theory from Berry.
Your Honor, I don't recall the judge even discussing that portion of his opinion.
I think that's correct.
She didn't. There were a number of areas of each expert's opinion that were never addressed.
Well,
As the court probably already knows, this involves a personal injury in which a 50-year-old woman from Cologne, Illinois, lost the lower portion of her left leg when her Toro time cutter mower went out of control because the steering and braking had been disconnected by some pins that were installed by Toro specifically for the purpose of moving the mower when it needed to be towed or moved. The criticism, as you know, of our experts was that the mower had no independent brake when these pins were pulled out to move it. There were no instructions and warnings that when the pins were out, you always had to make sure they were back in or you would have no brake, despite the fact that it did say they had a parking brake, which was really just a park lock. The difference is an independent service brake will stop the mower once it's moving. A park lock does not. The other two issues are an interlock, which the mower had, but were not wired to the pins, the disc gauge pins, and the lack of a rollover protective system, which is the seat belt and overhead bar to protect from injury in an overturn. First of all, this is a straightforward engineering case. It's not like Daubert. It's not, drug causation.
I must say, I don't understand how it's a straightforward engineering case. Everybody agrees that the lawnmower could have been built differently.
Correct.
Right? The question is whether it's tortious not to build it differently. Everything in the world can be safer. What's the theory under which it is tortious not to make it safer?
Because the ANSI standard, which Toro was so proud to say they complied with, actually says initially.
If you could use real words rather than
I'm sorry.
initialisms like ANSI, that would help us amateurs.
Thanks, Your Honor. I'm trying to save my time. The American National Standards Institute had a standard that Toro says it complied with, and it says, thou shalt have an independent service brake so that the mower can be stopped for all riding mowers. But there's an exception that says if it's a hydrostatic mower, you can incorporate it into the brakes. So technically, putting the only...
You're not dealing with my question.
I'm sorry.
Which is what makes something tortious, right? Presumably, it's the absence of cost-justified precautions.
Yes, sure.
You don't want to say that Toro has to make every lawnmower cost $1 million in order to avoid a 1% chance of a nicked finger, right? There has to be some cost justification for the precaution. I'm asking, what is the evidence in this record that the precautions for which the plaintiff demanded were cost justified?
Thank you, Your Honor. I will address that. Every one of the devices or the changes that the plaintiff's experts proposed were cost effective, in fact, in use in other lawnmowers.
Look, I am asking you to point to evidence in this record that the proposed precautions were cost justified. I'm not asking for lawyers' talk. I'm asking for evidence.
Your Honor, perhaps I misunderstood your question, and if so, I apologize. We did not do a cost analysis per machine. We simply pointed out through our experts that other machines use them and are marketed and sold every day. And these were devices that were either already on.
But you're now admitting that there is no evidence that these precautions were cost justified.
No, Your Honor.
One reason why I ask this is because it apparently is agreed that Toro makes a lawnmower with several of the precautions the plaintiffs want. And plaintiffs didn't buy it because it was too expensive, suggesting that the precautions are possible, easy, but not cost justified. Isn't that something one wants to deal with?
With all due respect, Your Honor, I think that oversimplifies the question. Because when people buy a lawnmower, they don't necessarily stand in the same shoes as Toro. They're not experts in machine design, guarding, and safety. They don't have a record as
Toro asserts, and without any response from you, that there have been no other accidents of this kind since 2005, which suggests that there's very little to gain from more precautions. Now, maybe that's wrong, but I didn't see any response from you.
Your Honor, the response is straightforward. I believe that the claim that you are talking about was that Toro submitted Mr. Porter's affidavit that they had no record of a case where a Toro time cutter had lost control because the toe pins were out. But they've had lots of loss of control accidents in which people were injured, severely injured, and killed. So the point being, the hazard identified by the safety engineers is its loss of control. And whether it happens because an operator forgets to put the pins back in after they move it 40 feet up a hill, or whether a motor fails, which happens, the idea is that one must have a consistent brake that is independent of the hydrostatic system to bring the machine to a stop and prevent loss of control and potential injury. Interestingly enough, we also pointed out in response to your question, Judge Estabrook, that Toro produced its own PowerPoint, which we quoted in our brief. They considered these things. They considered the litigation and said, maybe we should put ROPS on all of our residential mowers, even though they don't weigh 1,200 pounds.
And you were just referring to ROPS, rollover protection systems?
Rollover protective system, yes, Your Honor.
Can I just ask you, is the theory that the operator should be belted in as and unable to jump off as the mower goes over a cliff?
Yes, Your Honor.
I'll just have to say that seems pretty counterintuitive to me. Now that's entirely separate from the independent brake theory.
Yes, it is.
And maybe you should be aware that it was not that long ago that a case was argued in this court where the plaintiff said that the presence of a rollover cage on a forklift was tortious because it prevented her from jumping out.
Fortunately, Your Honor, I was not part of that case, and I'm not familiar with it, but I understand.
It's actually discussed in the briefs in this case. Two of us were on that case.
Well, Your Honor, I can tell you this, that the information that Mr. Berry presented, the articles showing 99% effectiveness in ROPS for tractors, mowers, and all implements showed the most likely way to prevent a serious injury was to belt the occupant so they didn't jump off like, unfortunately, Rebecca Hillman did, and it fell on her anyway.
Why didn't Mr. Berry test that theory? Isn't that what the district court's problem was? There was no testing, no method here.
Yes, that's correct, Your Honor. The problem setting up that test is actually setting up a reliable, relevant test with either human subjects or some kind of simulation. If you do the simulation, you can't necessarily set up the parameters for when an occupant would feel enough danger to jump off. That's why the seat belt is there, to give them the best chance of staying uninjured inside the space created by the overhead bar. There's really no way to do it. Simulation dummies, hybrid 3 dummies, cannot be programmed to react like human beings. They only have sensors on them to tell you, injury threshold and likelihood of injury. The experts which the district court excluded were a mechanical engineer with over 30 years of experience in failure analysis, safety engineering, accident reconstruction. He presented a 14-page Rule 26 report filled with calculations, information, and digital surveys. A digital survey, by the way, that was used by the defense expert to form his extensive opinions and conclusions, and which he claimed were within a reasonable degree of engineering certainty. Mr. Berry had over 40 years of experience. He actually designed rollover protective systems and had an extensive bibliography attached to his 30-page report. Mr. Kennett was a biomechanical engineer who was actually a researcher and experimenter in biomechanics and human tolerances for injury and protection or mitigation or prevention of injuries. His 15-page report was based on the actual medical records, the x-rays, and so forth. The facts relied upon by the plaintiff's experts were all virtually admitted. The accident reconstruction, how it happened, how much distance Mrs. Hillman would have had to apply a brake had she had one and stop the machine. All four of these, as the court said in Madden, a design defect is established under Iowa law by evidence of a practical, cost-effective alternative that was technologically feasible and that would have prevented plaintiff's injury. If there was an independent brake, Mr. Bielik's accident reconstruction showed she had enough time and distance to use that brake. By the way, this lady is an equipment operator, and a heavy equipment operator. Thomas Berry demonstrated with a long history of these devices that they were cost effective. And the evidence, Judge Easterbrook, that they were probably cost effective is in Toro's own documents that we quote in the brief and in their PowerPoint, in the fact that they now do have a ROPS as an option available for this mower.
They have a what?
Pardon me?
They have
a rollover protective system. I apologize, Your Honor.
You know, we're amateurs.
Where is the most specific evidence on the cost effectiveness of an independent brake?
It would be in Mr. Berry's report. And that actually less expensive mowers than this $3,000 Toro had independent brakes. And finally, Mr. Kennett pointed out that based on the x-rays and the way that both sides say the mower fell, that it was when the front end of the mower actually came down on Mrs. Hillman's leg and fractured it so badly it had to be amputated. That was the majority of the fall was all there. The 600 pounds came down on her leg, and then it tipped over. The defendants came in, told the court, wait a minute, we have an expert that says it would have flipped completely over and all 600 pounds would have come down on top of Mrs. Hillman's head and neck because it would have been protruding. No calculation, no test, no simulation, nothing. But unfortunately, that
Thank
and
you,
some,
counsel.
Pardon me?
Oh, thank you, counsel.
Thank you.
Good
morning.
Mr. Florence.
May it please the court, I'm Kirk Florence on behalf of the appellee, the Toro Company.
Mr. Florence, I and I think my colleagues would like you to focus on the question about the absence of a mechanical brake,
Yes, Your Honor.
which the district court did not discuss.
The issue was discussed in the lead-in part of the opinion, discussing at length all of the facts, including the fact that the braking system on this particular mower complied with the American National Standards Institute standard, and specifically has the type of service brake that is called out in that particular standard.
Is that an absolute defense under state law, compliance with
It
the
is
standard?
not, but it is a
No,
relevant
ever
fact.
since Carroll towing, that has not been a defense. Right, so we'd like you to concentrate on that question.
Right, and there is, the plaintiff's experts brought forth no testimony or evidence of any testing that such a brake would be feasible or would have prevented this accident in any way, shape, or form.
Well, they did testify it wouldn't have happened if there had been one. And Barry says it's makes it unreasonably dangerous not to include it. The district judge didn't engage on this question. How do we affirm a decision to exclude that opinion where the district judge didn't engage?
Number one, I don't believe the issue was preserved for appeal, and secondly, on top of that,
How was it not preserved for appeal?
I don't recall a specific discussion of that within the briefing, Your Honor.
It's there.
Okay. The district court was very clear that an ipsy-dixit statement by an expert that simply says the obvious is not sufficient to meet the Rule
That was
7
with
or
respect to causation, and it is pretty obvious, and that's really sort of a side point. The real question is Barry's opinion, right?
That's correct, yes.
Okay, can you focus on that?
Yes, Barry's opinion was focused. Do you want me to continue on the independent breaks?
Yes.
Okay.
That's the plaintiff's best argument. So that's what you need to address.
Right. And the order says what it says, and it is not addressed in there. The evidence was before the court challenging that testimony. Again, there's nothing that would show that there was anything feasible or helpful about to the jury.
It's on your other products, right?
It is on some other products.
Right. So there's nothing infeasible about this. And we've got Barry saying, look, these hydrostatic braking systems, and he cites some other folks as well, are not sufficiently reliable that you can safely have one of these things without an independent brake. Now, that may be right, it may be wrong, I don't know, but what's the basis for excluding that opinion?
The basis for excluding it, Your Honor, is that this is a very unique set of circumstances that led up to this.
That's not actually a very persuasive reason, because there could be and I understood Barry to be saying there are a lot of reasons and ways in which the hydrostatic braking may fail. Now, here, there's this tragic mistake by the plaintiff herself in pushing the pins in, failing to pull them back out again. I think we all understand that. And maybe your position is we don't have to protect her against her own folly like that, or her own absent-mindedness. If so, that's an argument. But Barry is responding to exactly that kind of theory and saying there are a lot of reasons that the main braking system may fail. That's why you need an independent one. What's wrong with that? As a matter of law that requires it to be excluded.
Because the proximate cause of this incident, Your Honor, was the plaintiff's admitted failure to re-engage the mower into its operation mode before they began to operate the mower itself. The mower had fully functioning brakes on it at the time of this incident. There was no need for an additional brake because it had that. There's no suggestion that the braking was not working or that it failed. It's only that the plaintiffs knew they needed to re-engage the mower's functionality and failed to do so.
So is this another version of the contention that an extra precaution is unnecessary because there's never been another accident like this? Where we treat 2005 as the reasonable equivalent of never.
It is, and 2005 is where we went back to because that was the scope of discovery.
Right. So when I put that to Mr. Crowley, he said, yes, but the record shows other loss of control accidents, not necessarily caused by failing to set the pins correctly. And if there are other loss of control accidents, presumably a mechanical brake could deal with those. So is there in this record some assessment of whether there are net benefits in having a mechanical brake?
I'm not aware of any. The other incidents that were discussed
not by the plaintiffs, not by the defendants, and no suggestion that the plaintiff's expert didn't know what he was talking about.
Right.
About mechanical brakes.
That's right. The problem is that this mechanical brake system really doesn't fit into the type of incidents that Mr. Berry discussed in his report and in his deposition. He was focused on a sideways or lateral type of rollover or a rear rollover.
No, though that was his evidence about the rollover cage, right? Correct. And we're not asking about the rollover cage. We're asking about a mechanical brake.
And there's no evidence to suggest that it would have made a difference at all.
Sure there is.
He said it did. He said it would have.
Bilick and Berry both said, it seems almost, and the district judge thought it was perfectly obvious that with a brake this wouldn't have happened.
Well, that would be a third brake on the mower, and there's no testing.
Well, the parking brake is useless for this purpose, right? Once the mower is moving. So the question is, does a backup brake in case the hydrostatic system fails, is that necessary for the mower to be reasonably safe?
And it's not, because there's not a record of incidents suggesting that this is even a concern or a problem with this mower.
So what do we make of Barry's account, for example, of he talks about patents, the failures of the so-called hydrostatic braking, that its braking capability does not eliminate the need for a service brake in case of transmission failure. Hydrostatic braking must not be considered the primary braking device for vehicles at static conditions, either with the engine running or the engine off, et cetera, et cetera. I mean, look, I don't claim to be an expert on this myself, but I'm reading Barry's report, and it is not. I'm looking for a sound reason to exclude it, particularly where the district judge didn't really address this point.
Had he tested this theory and come forward with evidence of that, it would have. Then there might be a basis.
What's the test?
Well, that's a complex maneuver. When you are dealing with a machine and you are accustomed to using the levers for the surface brake, and you have a separate parking brake, this is a third brake that would be operated either by hand or by a foot pedal that requires a lot of coordination.
You have it on your other, some of your other mowers?
I think they are on some.
Yeah.
But
so we know it's feasible,
typical.
Right?
It's not typical, and I don't know the reasons for it on the other.
This sounds to me like the kind of debate that you ought to have in front of a jury with competing experts. Give me a reason to. I'll try one more time. Can you give us a reason we should affirm the exclusion of Barry's opinion on this subject of an independent brake?
Because it doesn't fit with the failure that happened here in this case. It does not relate to the facts of the case, which is not that there was a failure of the hydrostatic motors or the braking system. It was disabled by the plaintiffs, and they knew they needed to reinstate it, and they didn't do so. That's the reason that the incident happened. It's not because of the lack of this independent third type of brake. As to the remainder of the court's opinion, this court should affirm on all points, because this is really an abuse of discretion standard. The de novo aspect of the court's review is limited to whether the district court performed inadequate gatekeeping.
That's part of your problem. Since the district court didn't discuss the mechanical brake part of that report, we can't apply an abuse of discretion standard because the district judge doesn't seem to have used any.
Well, as to all other aspects of the case, I believe that the district court did so. And hopefully I've addressed your point to your satisfaction on the independent brake issue. And the other issue to address is the failure to warn claim, and the district court reviewed that independently of the expert witness issues that we've been focusing on here today, and found that there was not proximate cause, and that was also not.
The plaintiff hasn't even argued that on appeal.
That's correct. That's correct. So I think that is a part of the order that can also be affirmed quickly. I also want to briefly just address the question of the district court's understanding of the incident itself. The court's order, I think, demonstrates very clearly that she understood the dynamics of this accident, and she laid them out in great detail. The parties, frankly, do not have any disagreement about the dynamics or the way that this accident happened. Finally, Your Honors, I think it's important to note, we talked about the ANSI, American National Standards Institute standards. They do include addressing the type of service break that is required here. That is a relevant factor in whether there is a defect in the case, or defect in this particular mower. And we would submit that there is no evidence to suggest that there was not one. And if the court has more questions, I'm happy to address those, but otherwise I will yield back my time. Thank you, Your Honors.
Thank you very much, counsel. The case is taken under advisement. Our third case for today is Simonson against Olanichak. Mr. Simonson.
I was just about to introduce myself, Your Honor. May it please the court, I'm Eric Simonson, counsel for plaintiff appellant Barbara Simonson. We are appealing a grant of summary judgment by the district court in which we contend, and I think the record shows, the district court failed in a number of respects to follow the law. It's actually a very simple case. It can be easily clouded by a lot of the things the defendants say, but it's very simple. My client entered into a legal services contract. That contract provided that she would be represented in litigation brought by her sister in an estate and trust matter. It was expanded shortly thereafter to include having the defendants file the necessary documents to close the estate. There was an estate and a trust. We don't have to go into the details of how those all fit together. A year later, it became apparent at the end of August of 2015 that the defendants were repudiating their obligations to file the estate documents. They then, in a dispute over fees, something that lawyers have all the time, good faith, there's no question in the record that this wasn't a good faith dispute over the amounts owed. There is no question in the record that plaintiff paid a majority of the amounts that were invoiced.
Is the theory that if you pay 51% of the amount billed, a failure to pay the other 49 is not a material breach?
No, that's not the theory, but the judge, the judge
Well,
is...
what is the theory for this not being a material breach?
Well, in Wisconsin, the court looks at a series of factors, and those have to be analyzed by a court under a summary judgment standard. That is, weighing the evidence, not making determinations as to credibility. If there is admissible evidence on both sides of an issue, it's left for the trier of fact. Trier of fact in this case would be a jury. When you go through what the court looked at and what the requirements are, it's not just the extent of the breach, although that's important. There are the factors laid out in the brief that the district court, in fact, tried to analyze a number of them in its initial order. In the reconsideration order, we pointed out that there was counter evidence on a lot of it, and that many of its conclusions, such as there was no chance that the defendants would get paid, that my client refused to pay them and would never pay them, were all adverse inferences from only a partial view of the record after ignoring evidence proffered by the plaintiffs in this case. So when you go through and look at those, there was not a proper summary judgment analysis made on that.
Can you direct us to a Wisconsin case that treated anything remotely comparable to this as less than or even as a disputable material breach?
I don't think that's the right question, and I don't have off the top.
That's my question.
I understand, Your Honor.
You can tell me why you don't think it's the right question.
Right. That's what
I'm not aware of any case that is comparable to this, saying that there's a jury issue where one side is refusing to pay more than, or a very substantial portion of the price.
Yeah, except that that's not the facts in this case.
Well, she was not making the payments.
She-
She was insisting that the defendants wait until the estate was closed. They said, we're not going to be your banker anymore, right?
That is correct. Now, the facts in the record in this case are that a large amount was paid in full and on time. Other progress payments were made while she was trying to have discussions as to the reasonableness and certain other matters that might have been overpaid or improperly paid. There is no suggestion that the defendants believed it was a material breach at all until July at most, when they said, please pay
Right.
us, you really have to pay.
And by late August said, we're not going to do more until you pay us. As you described that as an unambiguous repudiation, right?
Well, they didn't say. They said that they refused to file the estate documents that they had agreed to do, and said that they were going to go to the court to request permission to withdraw as counsel of record
You described it in your reply brief as an unambiguous repudiation.
of the obligation to file the
Right.
estate documents.
And there was
Correct.
no harm to your client until months later, correct?
Well, until November
Right.
9th. Correct.
Right.
Yes.
After August 24th, 2015, did she ask the defendants, communicate in a way that said, I want you to do more work for me?
She included she copied them on correspondence that opposing counsel had written to her regarding various administrative matters. Who had also,
counsel,
Yes.
did she ask the defendants to do more legal work for her after this unambiguous repudiation on August 24th?
The unambiguous repudiation was for the estate documents, not for the other representation.
May I ask
counsel.
the question again?
Yes.
Is there evidence in the record that the plaintiff asked the defendants to do legal work after August 24th, 2015, when they said, until you pay us, we're not doing anything more?
I don't believe, well, there is an ambiguity there. Their counsel was copied on various correspondence relating to what ultimately became.
I'll take that as a no.
No, I don't think so. I think you should take it as it is ambiguous. And
What's
there are-
ambiguous?
She copied her, who she thought was her counsel, on correspondence, as well as to and her counsel, Mr. Kruger, was copied on correspondence to her from counsel to her sister. So it's not entirely clear that she didn't ask them to do anything. She made sure that they were aware of things.
Thank you.
The simple case here is that, was there a contract, and which there was it terminated? Well, it couldn't have been terminated until after the 24th of August, and there was literally no communication between defendants and my client where the defendants had mentioned anything about either the results of the probate court or their desire to terminate the contract, which had to be by reasonable notice. So the contract, we contend, continued all the way through. Whether or not my client was relying in a particular sense for particular services, she certainly was relying on them to represent her in court, and they did not. And as a result, she was removed. And the way it works in Wisconsin is that a probate court does not have the power to intervene in the actions of a personal representative or a trustee absent a finding of a breach of fiduciary duty. In this case, the court found a breach of fiduciary duty by failing to file estate documents that, in fact, she had filed in September and early October, and perhaps most importantly, for failing to show up at a hearing where she thought her lawyers were going to show up. And so that is the nature of the claim. And
Where is the evidence in the record that she expected her lawyers to show up?
it's in her affidavit that was in front of the court. It's very
Okay.
clear statements. to that effect.
And I guess this goes back to Judge Hamilton's questions. Was she having any direct communication? Is there anything in the record that she was having, other than copying them on emails?
There were communications that went back and forth in September and October. I'm not sure I can point them out in the record,
But
but I know
nothing
they
saying
did.
about the hearing?
No,
At that point, the motion to withdraw had been granted.
she was unaware of that, and there's nothing in the record to suggest otherwise. There's nothing in the record to suggest that she was mailed. She was not the notification from the court. She was not provided the notification for the November 9th hearing. In fact, defendants were.
You know, this case is interesting to me because your client is a lawyer, and obviously there's some relaxing of standards for pro se litigants, but it defies common sense, and that she would not know the motion had been, or she wouldn't have called the clerk's office. What about this November 9th hearing? Why didn't she do something?
I think she was relying on the fact that what she got no official notice. Her understanding was that the court gives official notice to the parties. It did not in this case. There's no question about that in the record. She thought she had counsel who was copied on everything, who would tell her what to do, or at least tell her, hey, you haven't paid, maybe get a different lawyer.
Other than her copying counsel, why is it reasonable for her to believe that they were still her lawyers at that point?
Well, I think there was a lot of reason to believe. First of all, she never got actual termination of the contract where she was representing. There's no question that is not in dispute in the record. It is not in dispute in the record that she did not know of the outcome of the withdrawal motion, and in fact, that was not unusual, as there is evidence in the record in the affidavit of my client that oftentimes the judge took months to make decisions on routine matters. And so in the course of roughly a month and a half, it didn't surprise her, particularly because she had objected within 5 days and thought there might be a hearing on that or something else. She had no idea that even before she was able to get her response papers in just 2 days, that the court had, in effect, granted the motion to withdraw. Given the fact that she had opposing counsel who was still copying them on correspondence, I don't think she had a reason to believe it. She's not a Wisconsin lawyer, she's not a litigator, and it seemed to be perfectly reasonable that experienced counsel who she thought were still representing her would give her a heads up on something.
Mr. Simonson, I believe the record indicates that a week after the August 24th correspondence that you describe as an unambiguous repudiation, the plaintiff filed herself a petition to extend the time to close the estate. What led her to do that herself?
Well, she's allowed to do it herself, and I think she was concerned, given the defendant's repudiation of their promise to file those estate documents, that if she didn't do that in an effort to reduce and mitigate damages, she'd have a lot of problems. So she went ahead and did it herself in order to minimize any sort of problems for her, given the recalcitrance of the defendants. I will save the rest of my time for rebuttal. Thank you very much.
Certainly, counsel. Mr. Scipio.
Good morning, Your Honors. May it please the Court, my name is Attorney Vincent Scipio. I represent the defendant appellees Thomas Olenichak, Stephen Krieger, and the law firm of Conway, Olenichak, and Jerry. There are many reasons for this court to affirm the district court's order. As I state in our brief, the district court chose to dismiss the plaintiff's claims because the undisputed evidence in the record was that she materially breached the legal services agreement by failing to pay my client's legal fees in full and on time, and therefore excuse my client from any further
Counsel, why Why did your clients not send plaintiff a copy of the probate court's quick order granting their withdrawal?
Unfortunately, there's no evidence in the record, such as an email or a letter showing that they mailed a copy of the order from the court. So there's no direct evidence of that. I also, unfortunately, don't have anything from the court showing that they mailed a copy to her.
So that would seem to have prevented a lot of this dispute.
Well, as the court was just noted, after that date, the plaintiff did represent herself pro se in the probate manner. In addition to filing the request for the extension, she then did file the necessary paperwork to close the estate herself. Beyond that, she then was communicating with the opposing counsel in the probate manner, and she sent them a letter acknowledging the November 9 hearing date. She had received a copy of the notice of the hearing. Counsel argued here that, again, that his client did not have notice of the November 9 hearing. That went up to the Court of Appeals in Wisconsin State Court, and they ruled that she did have notice of the November 9 hearing, in part based on her own letter, where she wrote in it, "I'm aware of the November 9 hearing. I'm not available, and so unless it's moved, I need to petition the court to move the hearing date." She didn't do that. She didn't attend the November 9 hearing. There was no communications between August 26th, 2015 and the November 9 hearing between the plaintiff and my client about doing work or attending hearings. The only communication there after that was about the unpaid bills. She stopped paying my client's bills in January. By August, they were over $80,000 in unpaid bills. No reasonable jury could find that that wasn't a material breach.
So what was the total billing from the beginning of the engagement until August of 2015?
So they were first retained in 2014. She paid the first 6 invoices on time. I don't know the exact amount.
I'm not asking, I'm asking for a ballpark.
I think it's around 60 to 70,000.
For the first 6?
Yeah. I have a question about timing here. In terms of whether this was a material breach, your clients have a client who had paid on time and in full for a long time, 6 months, and then there was a drop off, and then there was communication about fees, right? And there were some payments made. I guess, why didn't is there anything in the record about why they moved to withdraw when they did? Because at that point, it's almost as if they were leading her on as to the representation, right? And then there's a trigger point where the court's like, you're late closing the estates, and they're like, we're out. Isn't that prejudicial? And tell me what you'd say to that.
Sure. So the first email that we have was back in April, where they asked her, you haven't paid our last 4 bills. But the reason for the timing is on June 5th, the court entered a final order with deadlines to close the estate. And that order was sent to the plaintiff, and then there's email exchanges between the plaintiff and my client in July, where she says, I don't have the money to pay you to continue to do this. I will take care of these
Did she
deadlines.
really say that, or was she just concerned about the expenditure and the dissipation of the funds? Was it, I don't have the money? Because the money was there in the estate, right?
The exact words she used was, I quote, cannot pay to have everything reviewed by you, period, end quote. And then the back and forth was, she agreed that they would take a back seat and be available only upon request. And so from there on, and then they said, okay, well, we're not going to do any more work until you pay our bills. And that's when she took the position that, well, she was going to dispute some of their bills, and she was going to work on putting together a list of why she thought their bills were inflated or too much or whatever she thought. And then she never did that. And she testified it was because she was too busy. It wasn't a priority for her. And so I think it all comes out of, we had this June 5 order where certain deadlines needed to be made, then a July 20th and 21st email exchange where she says, I cannot pay you to do this. I'm going to do this myself. Take a back seat. only be available if I ask, upon request, if I ask you to do something. Over the next month then, there's emails where they are demanding payment. I mean, she owes $80,000 at that point. She's telling them, I cannot pay you to do all of this. At that point, she's going to be handling it herself. They want to get paid. They're owed $80,000. I think they had enough leeway with that. And so then there's exchanges right on the 24th where she had gotten the notice that the estate had not been closed by August 3rd, which is the paperwork she ultimately ended up filing in September. And that's where she said she wanted them to do it. And they said, absolutely not. We're not doing this. You owe us $80,000. We need payment. And that led to then the August 24th motion to withdraw, which was granted. I think that all of her actions after August 24th clearly shows that she did not think my clients represented her anymore. There was no communications about the case. Per their July 20th agreement, there was no request for them to do anything. There was no discussions about them attending the November 9 hearing.
What about the early statements, early in the representation? I think it was, I'm not sure which attorney, Olenachek, am I pronouncing that correctly? Olenachek said, oh yeah, we got to close the estate, we got to take care of that. There were some oral statements. What do you say to that evidence?
So it goes back to one of the reasons, it goes back to my argument that there's many reasons why this order should be affirmed. That was the plaintiff's testimony that she had this oral conversation. I believe it was with Attorney Krieger. The deadline for that filing was August 3rd of 2015. And to the extent that deadline wouldn't been met, was not met, it is barred by the statute of limitations. Any acts occurring before, I believe it's August 20th of 2015 are time barred. A 6 years statute of limitations apply to the plaintiff's claims, and she first filed suit on August 20th of 2021 in Connecticut. That ended up getting dismissed, but it told the statute of limitations. And so that's another wrinkle in the case where anything that occurred before August 20th of 2015 falls outside of the statute of limitations. She claims that she thought they were going to file the necessary paperwork to close the estate. She testified about this conversation earlier. The deadline was August 3rd. To the extent she complains that it wasn't filed by August 3rd, it's outside the statute of limitations. We would argue it falls under that July 20th agreement of where she said she was going to take care of all the further deadlines. And then she ultimately was the person who filed the paperwork to close the estate in August of 2015. One of the arguments that the plaintiff makes in this case is on the de novo standard. I think as the court knows that this court can affirm the district court summary judgment order on any basis that were raised in the lower court that was preserved. She described this as, quote, right for the wrong reasons analysis. And I just want to make sure that the court understands we don't argue or allege that the district court got it right for the wrong reasons. It got it right for one of the possible right reasons. There's many reasons, in addition to the fact that the plaintiff herself materially breached the contract and the fact that most of her complaints fall outside the statute of limitations. She had no expert. And so there are, this is a legal malpractice case. Legal malpractice in Wisconsin can arise under tort or contract. Here she alleges it arises under contract, but it's very clear under Wisconsin law that whether it arises under contract or tort, you need an expert when the issues involve specialized knowledge. Here she bases it on contract, where all the contract says is that we will represent you in a dispute with your sister. Throughout her briefing, she alleges that there are specific contractual obligations that have been agreed upon. She never says where those come from or points to anything. And when it comes to what a reasonable probate attorney would do under the same or similar circumstances in a case like this, that requires expert testimony. It requires an expert in the probate legal field to come and testify about, well, here's what is necessary to do to probate the estate and administer the trust. Here's the deadlines that are going to come up. Here was the discussion between them. Here's what you need to do. Here's what needs to be filed. Presented with a discussion or agreement where they were going to take a back seat. Here's what needed to be done. And then also, when you move to withdraw, here is what a reasonable attorney would do under these circumstances. Those go to standard of care, go to whether they breached a contractual duty, but there's also causation and damages issues in this case that would have required an expert. She had no Rule 26A2 disclosures at all. And so she argues that the district court, or that the probate court in the state law matter, that she would have gotten a more favorable distribution but for my client's alleged breach. And that's where a jury would be left to just guess and speculate. They'd have no basis to even understand what was necessary to be done in the probate matter and why that resulted in a less favorable result for her. In addition to liability and damages, there's also some causation issues here. As I indicated in my briefing, the fact that she had filed that petition to extend the deadlines in the probate matter and got herself 2 more months to close the estate gave her an opportunity to do it herself or to hire another attorney to file the necessary paperwork. She then tried to do it herself. The court sent her a letter saying this is insufficient. You need, I'll give you this new deadline to redo it. She acknowledges, she testified, I received that letter from the probate court. At this point, we're in September of 2015, where the court had given her an extension, given her an opportunity, and now given her a second opportunity. And she did nothing. She didn't file anything else. She didn't hire any other attorney. She let that deadline lapse. That's when the court issued that is when her sister filed a motion to remove her, which led to the November 9 hearing. And so in terms of causation, there's cases we cite in our brief where that's an intervening cause, where she has stepped up and gotten the extension to file the necessary paperwork that she believes my client should have done, that cuts off the causation in terms of a legal malpractice case. In another wrinkle in the case, her own testimony is that the probate court later on admitted he made a mistake, that she had filed the correct necessary paperwork in September to close the estate. And so by her own testimony, the judge made a mistake. And so it really, her allegation that we needed to file the necessary paperwork to close the estate, and then she attempted to file it, and then she did, but it wasn't adequate. Turns out that was a mistake made by the probate court, by the plaintiff's own admission. So there's just all these problems, not only with liability, but causation issues, and then damages, especially in a case like this where...
I take it you don't think we need to reach those issues.
I think you can affirm on any of these issues. I mean, the district court, I think, got it right. She owed more than $80,000. She had failed to pay for 8 months. My client repeatedly emailed her and said, "We're not serving as your bank anymore. You need to pay us." She didn't pay them. She owed them all this money. The contract allowed them to terminate and withdraw. I don't know where this argument comes that they couldn't terminate until after the August 24th. Plaintiff's counsel doesn't cite to the contract or any case or any law that says that's the case. To the extent it's a standard of care, they don't have an expert to show it. I mean, there's multiple emails. We're not doing any more work. You owe us a lot of money. We're moving to withdraw. They did move to withdraw. And then in the probate court's order, it said their motion is granted, they're no longer representing her, and they owe no further legal obligations to her. There are many, many, many reasons to affirm the district court's order. I think the district court got it right. But to preserve all these issues, I think, as Your Honor said, a lot of the arguments here defy common sense. I don't understand why the plaintiff herself, who was an attorney, thought my clients were just going to continue representing them unpaid. Thank you.
Anything further, Mr. Simonson?
Just a few brief comments. First, I'd like to emphasize, and I know Judge Hamilton, I didn't do a particularly good job of responding on the material breach and the standard of law. You need to look at, on page 26, the restatement second of contracts, and it is there is no evidence in the record that even the defendants thought they were never going to get paid. And interest accrued and had been paid on all late balances. The damages they would have suffered would have been paid for. I want to just cover a couple other corrections from what I heard. The fee dispute did not arise after there were arrearages. The fee dispute arose in January when my client received bills that included a bunch of work for things that they weren't meant to do and didn't say they were going to do. That's when it started. It wasn't a question of, I'm going to come up with an excuse not to pay somebody. And indeed, the only evidence of my client's intention and likelihood to get paid is that she intended to pay them. She was required to scrutinize their bills under the June 5th order. She was required as a fiduciary to only pay what made sense and figured, why are they getting so hot under the collar under this? They're getting interest. She made a payment on July 30th. She just kept making payments in order to say, look, I'm not walking away from this obligation, but I need clarity before I can make the payment. So that's, I think, all I wanted to raise here, unless there's something else from the court.
About the statute of limitations.
Yes.
If we buy the argument that anything, well, I think it's August 3rd, 2015, what could possibly be in the case?
Well, what could
Given
possibly,
the
first of all,
statute
there
of
are two
limitations.
breaches. There's the failure to file the estate documents in a timely manner, and also the failure to appear in a litigation, in the same litigation matter.
So the first would still be timely,
Oh, it's clearly timely because they're
even if we don't buy the evidence on the.
both. Yeah, I believe even the first, the contract would be timely, or at least there's an issue of fact here, because the court kept extending, and she just figured they can get extensions. The court was very good about that, and it was only on August 24th where they said, "Forget it, we ain't doing nothing for you," that she realized that there had been a breach. That doesn't affect, though, their failure to appear at the hearing. And in the alternative basis, it must be an alternative basis for the entire judgment, which is no liability for either of those breaches for any of the defendants. And so that you can't consider on appeal here as a separate alternative basis. Thank you.
Thank you, Mr. Simonson. The case is taken under advisement. We'll hear argument now in the case of Strickland against Dart. Mr. Hosseini.
Good morning, Your Honor. May it please the court, my name is Arvin Hosseini, and I represent Michelle Strickland, the appellant. We're here because of a deeply concerning and pervasive issue within the Cook County Sheriff's Department. And while one man, Sheriff Sandifer, is at the center of this case, his actions directly enabled and fostered discriminatory behavior in his ranks. And his actions were further enabled by the systemic indifference of the Sheriff's Office towards workplace hostility. Now we're asking this court to reverse the decision of the district court, who made two errors. First, by missing the forest for the trees, thus missing the pervasiveness of the hostility, of which Sandifer is the central actor. And second, by not considering the employer's liability in their negligent discovery of harassment. So turning to my first point, the pervasiveness of the harassment. The district court erred by doing exactly what this court has repeatedly said not to do. In the Mason decision, this court said that incidents should not be carved up and evaluated individually. And so if we look at the totality of the circumstances, a clear pattern of racially charged and sexually charged behavior throughout the transportation unit emerges. Now, today we only have time to go through a few of those, so I'd like to start with the roll call incident, where other officers egged Sandifer on to use the N-word. And so he did. Several times. Now, Sandifer later admits that he used this word for shock value and that he knew that it was totally unacceptable. And yet, he justified its use by saying, and I quote, "If other officers use the N-word, then it belongs to everybody." That's from page 95 of his second deposition.
And if that's not an admission of pervasiveness, then I don't know what is. Now, time and time again, this court has emphasized the extreme severity of this word.
Was plaintiff present for that?
Plaintiff was not present for that particular incident, Your Honor. However, this court has stated in Johnson that evidence that the same supervisors made racially derogatory comments to other employees in the same position.
It's relevant.
Of course. Now, time and time again, this court has ruled on the severity of that word. Now, if you put this into context with the brother incident, which the appellees make light of, on the basis that, well, Sandefur didn't call Strickland the N-word. But of course, we know from the Pascal decision that this makes no difference to the listener, given the historical context. In fact, I believe this court referred to that word as pure anathema. Now, turning to sexism, there's the jacket incident, where Sergeant Sandefur told Officer Voitas to take charge, show her who the man is, and take the jacket. Now, appellees will tell you this is a joke, but that's not a joke. This is a sergeant, yet again taking a benign interaction and turning it into an opportunity to divide a subordinate and have another subordinate assert dominance on his female coworker by force. Now, every other one of these 20 instances that I wish we could go into paint this broader pattern of sexually charged and racially charged discriminatory behavior that Sandefur admits in his deposition is pervasive in the sheriff's office. Now, the appellees will want this court to evaluate each incident separately under a microscope in hopes that this clear and pervasive pattern will be missed. And so I'd like to urge this court to step back and see the whole forest and not just the trees. Now, turning to the question of employer liability, the sheriff's office used their policy as an excuse to stick their heads in the sand and ignore well-known discrimination. I believe the appellees will come up here and tell you all about the Lambert decision, but they probably won't tell you about this court's decision just last year in EEOC versus Village, reiterating, and I quote, that an employee need not specifically comply with the company's internal procedure so long as the employer is adequately put on notice. That decision goes on to reiterate the Parkins decision. By reporting harassment to the point person, an employee satisfies the notice requirement. And as luck would have it, the Office of Professional Review, the point person within the Sheriff's Department, was put on notice when they received an EEOC charge. But they brushed it off. They conducted a sham investigation, only interviewed Strickland, and then determined that, you know what, everything is fine. Now, that's curious because 7 months later, once she filed their proper complaint form that they wanted, they finally acted. Now, it's worth noting that this OPR complaint substantively was identical to that EEOC charge that Strickland had filed 7 months prior. Now, before this, it's also worth noting that Strickland had told 2 lieutenants who were directly above Sandefur about the behavior. The first one discouraged her from making a report, which alone is a basis of negligence recognized.
That was about the stupidness comment?
I'm referring specifically to her statements to Lieutenant Ledesma,
yes,
who then discouraged her from reporting.
What exactly did she report to him? What does the evidence show?
I apologize, Your Honor.
I believe it shows this was about the no time for stupidness comment in November of 2018.
Yes,
is that right?
Yes,
okay.
Your Honor. I believe that's correct.
And that's the only one, right?
I believe there were more than just that, but I apologize. I might be getting them mistaken.
We're getting into the trees.
Yes. But the point that I'm trying to make here is that this is
what she talked with him about was very little of the larger case. What about Lieutenant Martin?
Well, Lieutenant Martin,
who told her file the OPR report.
Yeah. On 4 or 5 different occasions, he refused to lift a finger, despite later admitting that he could have brought this matter up the ladder himself. So what this is showing us is that their internal policy isn't doing anything to enable the sheriff's office to investigate harassment claims as required under Farragher. Rather, it's giving them an excuse to hide behind in it and creating additional hoops for victim of harassment to have to jump through.
Let me throw a view of this case and invite your response. This plaintiff did not suffer any tangible employment circumstances in the language of hostile environment cases, right?
Tangible in terms of like physical harm?
She was not denied a promotion or a raise. She wasn't disciplined or demoted, right?
No, Your Honor.
Okay. She took her concerns to Lieutenant Martin, who told her to use the formal complaint process.
Correct.
And then when she did, Sandifer was very quickly transferred to, and the, at least as near as I can tell, the racially charged language, or at least the worst of it, ended as far as her experience goes. And fairly soon after that, she left the office, right?
Correct.
So that sounds, from one point of view, like a policy that works.
Your Honor, I see that I'm almost out of time. I might run over, but to answer your question, that doesn't prove that the policy works. That just proves that they finally chose to act once Strickland jumps through the hoops that they asked her to jump through. Keep in mind, the Office of Professional Review knew about this situation. They acknowledged this situation by interviewing only Strickland. And they did nothing for 7 months. Your Honor, I see that I'm out of time. If there are no more questions, I'll reserve the rest of my time for rebuttal. Thank you.
Certainly, counsel. Ms. Hassan.
Good morning, Your Honors. Nazia Hassan, arguing on behalf of the appellees. We respectfully ask that this court affirm the district court's grant of summary judgment for 2 reasons. First, there can be no basis for employer liability based on this record. Second, there was no hostile work environment based on the undisputed facts. First, Ms. Strickland does not meaningfully dispute that Sergeant Sandifer was not her supervisor for Title VII purposes and has forfeited that issue on appeal. He had no authority to hire, fire, otherwise discipline her, and on that basis alone, this court can affirm the district court's ruling. As Your Honor pointed out, there was no meaningful alteration of Ms. Strickland's work. There was no difference in her employment. And
There's no tangible employment action.
Correct. There's no
The
tangible.
question is whether this was sufficiently severe or pervasive.
Yes, but in order to be found severe or pervasive, there would have to be a tangible employment action
No,
for a hostile work environment claim.
no.
No.
That's the whole point. A hostile work environment claim does not require tangible employment action.
I'm sorry, I'm misusing the term. I think it's alteration in the conditions of her
working
employment.
conditions.
Yes,
Yes.
I didn't mean to conflate the two. So there was no alteration of her work environment. As we discussed, the Sheriff's Office has a established process for submitting complaints about misconduct. Ms. Strickland was cautioned repeatedly by Lieutenant Martin to submit those complaints in writing, and she failed to do so. And later, when she did in 2019 submit a complaint in writing to the Office of Professional Regulation, swift action was taken by the Sheriff's Office to remedy her complaints.
So why shouldn't we treat the EEOC charge in July of 2018 as sufficient notice of at least a problem to the employer and as of that time?
Your Honor, it was treated as a investigated matter. The Sheriff's Office did interview Ms. Strickland about her concerns.
The plaintiff is telling us they did nothing more. Is that right?
I don't know from the record. I don't believe that the Sheriff's Office took any action to transfer Sandifer at that time.
Did they talk to Sandifer?
I believe that they would have talked to him, but I can't point to.
It sounds like
the
you're
record.
guessing.
Yes.
Let's not do that.
Okay. So the 2018 EEOC charge of discrimination is not a complaint that the Sheriff's Office would investigate in the traditional way that they investigate charges of misconduct at the Sheriff's Office. The Sheriff's Office superior staff who Ms. Strickland made a complaint to could not do anything additional without her statements in writing about what occurred and what she was actually complaining about.
I'm confused. Was there some kind of official policy in place that limited an investigation of an EEOC charge?
No, Your Honor, there is no such policy.
Okay. And I understand that might draw a somewhat more defensive response from a bureaucracy than an OPR complaint aimed at a particular individual or group of leaders. But I'm having trouble understanding why that charge was not at least sufficient notice to put the employer on notice for potential liability for actions after that.
Your Honor, it may have been, but as we turn to the second argument, the conduct was not severe or pervasive.
Well, that argument is a lot easier if you're limited to talking about things that occurred after the sheriff's office got the EEOC report, because there wasn't much.
Correct. There wasn't much.
Some of the worst stuff that we all have read about came earlier, right?
Yes.
Okay.
So, although appellant asked this court to not look at each instance individually, in this situation you have to. Many of the comments that are complained about have no tangential reference to race or gender. They're more of a complaint about an unpleasant workplace, which Title VII does not protect an employee from. It's not a civility code, as this court has held repeatedly. Ms. Strickland complained about conduct that the rest of the sheriff's office was also subject to. There was no indication. Judge Hamilton mentioned the no time for stupidness. There's no reference to race or gender in that comment whatsoever. And in fact, when Lieutenant Ledesma told her, "Don't worry about it, I'll take care of it," he did. He put her back in the rotation, which is the issue that she was complaining about. There's no basis for the sheriff's office to be held liable for this conduct. And there's no basis for Section 1983 liability against Sergeant Sandifer for the same conduct. There was no severe conduct or pervasive conduct. This is a smattering of complaints.
What do we make of Sandifer's comment that his brother was the worst in I know, directly to plaintiff? I'm not sure what it means, but it's surely pretty offensive.
I'm not here to defend Sergeant Sandifer's comment. It is certainly offensive, bizarre, as the district court put it, but it's not rising to the level of severe or pervasive conduct in this context. It's a one-time incident that's not directed at Ms. Strickland. It's not referencing her or her race or her gender.
That's an interesting spin on it.
What I mean, Your Honor, is he was not using that racial epithet directed at her. It was a conversation with her, yes. But the conduct was never physically harassing or threatening or abusive, which is also part of the analysis that this court must use. We ask that this court affirm the district court's ruling on summary judgment unless this court has any further questions.
Thank you, counsel.
Thank you.
Mr. Hosseini, anything further?
Yes, sir.
I'd first like to address the comments about how there was no alteration to her workplace. But how could there not be? Officer Strickland works at a correctional facility, an inherently dangerous job where she has to depend on her fellow officers. As Sandifer himself puts it, we're all blue. And yet, Sandifer is going through and dividing her and diminishing her for being a woman, dividing her and diminishing her for being black, And she has to walk into that kind of a workplace, constantly being reminded that despite the fact that she's in equal rank with others around her, that she is in fact lower. Now, this court has constantly referenced the severe impact of that particular word, Bailey, McGinnis, Hebrowski, over and over again. Now, when it comes to the facially neutral language, there's a lot of statements, a lot of incidences that I'm hearing that appellees are trying to diminish them and treat them like they're nothing because they're facially neutral. But this court has recognized, particularly under Dandy versus UPS, that context matters. Further, the Supreme Court ruled that historical context in particular matters. So when we're talking about phrases like boy, girl, you people, facially, they may be neutral, but in reality, the historical context comes in and it colors everything else that's here. That's why we're urging the forest for the trees. Finally, what I want to hit on here is that comment that the jacket incident was apparently not threatening. When you are commanding an officer below you to take something from somebody else by force because they are a woman, I don't think that stands up to scrutiny. If there are no further questions, I yield the remainder of my time. Thank you very much.
Thank you, counsel. The case is taken under advisement. Case number 5 for argument today is United States against Betty.
Do you all have a phone number? Okay.
Yes, call him. Yet more proof of why this is a bad idea. And we are ready to proceed in the United States against Betty. Mr. Merrill.
Yes, good morning, Your Honors, and may it please the court, and thank you for the accommodation with respect to Zoom. I spend part of my time in Utah and live in Provo when I'm here. And right before I was heading to the airport yesterday, there was the shooting, which is about 20 minutes from here, and in between where I live and the airport, and it was very, very difficult to get to the airport. I tried, but it was unsuccessful. So thank you for that. So we're here on a relatively simple issue, and that is where Mr. Betty's, did the district court accurately calculate Mr. Betty's sentencing guidelines? That, of course, is an important procedure, and whether or not that procedure was followed, accurate procedures, adequate procedures were followed, is, of course, subject to de novo review by this court. We're on appeal. There are two primary guidelines issues that affected Mr. Betty's calculations. One related to whether or not his counts, or 4 counts that he pled to, and whether the counts could be grouped. In the PSR, which the court accepted, there was an error, and the error simply said that under 3D1.2, this is sentencing guideline, D, that there are certain sections that are excluded from that subsection. The PSR and the court accepted that exclusion applied to the entire section, including subsections A through C. Whereas it's clear under the law that we've cited and under the language of 3D1.2 that those exclusions apply only to D. Now, so the court should have considered the grouping rules under 3D1.2B and C. Had it done so, that would have saved Mr. Betty 3 points. And under the guidelines that the court calculated, he ended up with life guidelines range, and it would have brought him down to 292 to 365. And our submission is that makes a huge difference in terms of courts in these types of cases frequently sentence below the guidelines range because these types of charges end up with...
If I understand correctly, the judge asked whether Betty had any objection to the guidelines calculation, and counsel said no. Why isn't that the end? Why isn't that waiver?
Well, it's not waiver because earlier in the hearing, the court had said the first issue we're going to consider is Mr. Betty's objection to double counting under the guidelines. And this is part of what that double counting objection was. His counsel went through an argument and the court rejected that argument. And then the court said, you can nonetheless still argue that as a sentencing factor, but for purposes of today's sentencing, I'm rejecting that argument.
So, excuse me, Mr. Merrill, we've got 2 separate double counting arguments, right? That you're making.
I think
one of them is sort of a general 3D 1.2, 4B 1.5. It's the same conduct, and we had some older case law that said avoid double counting, but it's pretty clear under the guidelines that unless there's a prohibition, you can and should double count. Worry about those effects under 3553A. Did Mr. Betty and his counsel make this specific argument about grouping under 3D 1.2B and C in the sentencing argument or memorandum?
No.
So that's your best argument then is forfeiture and plain error on that, right? Because that's not an objection that was actually withdrawn or made or not withdrawn or withdrawn, whatever. So, right?
Yes. I think the best way to put it is that counsel below made a generic double counting argument presumably didn't catch the error that we're pointing out in the reply. But so the court never dealt with that issue.
Okay.
And so if the court viewed double counting, a general double counting argument, as insufficient to preserve,
I can tell you as a former district judge, I would certainly not treat that as having raised the specific issue as something that I needed to address. But that puts you in plain error territory, I think. But could I ask you to address a point the government made, which was that there actually were offsetting errors here, in essence, that under 2G 2.2 C1, I'm going to delete irrelevant language. If the offense involved, and this is the receiving child pornography offense, if the offense involved causing a minor to engage in sexually explicit conduct for the purpose of producing a visual depiction of such conduct, then use the 2G 2.1 guideline. That certainly seems to fit the facts here. Go ahead.
Yeah, that was never raised not in the PSR or by the government below. Never discussed the
right. But you're raising stuff that was never raised below. So this is the question. Ultimately, is how do we use our? Is this a situation where we need to send it back, particularly since nobody thought the guidelines were actually very helpful here?
Well, in that situation, I don't believe that guideline would necessarily apply.
Why not?
And because I think it's clear that. Can you just tell me, Your Honor, I've got the wrong guideline in front of me. Did you say 2G 2.2
C1 from the 2018 book?
Yes, and I think the other reason is that this didn't involve notice or advertisement. That has never been.
It doesn't have to. That's an or. If the offense involved causing a minor to engage in sexually explicit conduct, and this photograph would certainly count, for the purpose of producing a visual depiction of such conduct, like a photograph, then you use 2G 2.1, and that removes the some of the double counting effect that you're talking about. So you've made your point.
Yes. Thank you, Your Honor. And but under this, we believe there were several errors. That was certainly one of them, the one we pointed out initially, and that if the district court were to agree with us, if this were to be remanded, then that could save Mr. Betty 3 points. The other error is under 2G 2.1, which applied to count 2, and in its subsections B2, where his calculation was enhanced for the commission of a sexual act. It's pretty clear. That's what was asserted in the PSR. That's what the court accepted below. There was never any discussion of a different standard.
There was never any discussion of that, but would you agree with me that what is set forth with respect to that satisfies the statutory definition of sexual contact, which refers to any person?
It appears to do so, Your Honor. I would agree.
So what's the harm? Mm-hmm.
Well, the harm is that there are several factors, that were we believe that the court got wrong. The other one is the court allowed the government argued to a couple of facts that were not anywhere in the record. Were extremely.
You're shifting to an entirely different issue, but I can go there with you. On those 2 points, the victim's attempted suicide and the defendant's attempts to contact other minors. Both of those points were made on the record, and defendant expressly agreed with one of them and made no effort to dispute the other. Why should we treat this as a due process violation?
I don't believe the record indicates he expressly agreed. It was at the end of a long soliloquy by the government, most of which involved information that he had pled to and was in the PSR, and then the government snuck in these 2 points, and just generically, the court said, do you agree with the government's version of the offense? Now, we believe counsel should have objected, but it was obviously prejudicial that counsel did not, and prejudicial that these things came up. And so we don't think he was specifically agreeing with those 2 points, because the one point is in fact not true. She did not attempt suicide. The records at best, hearsay within hearsay, support that she was hospitalized for suicidal ideation, and that's simply not the same. I see I'm out of time, Your Honor.
Thank you very much, Mr. Merrill. Mr. Kinstra.
May it please the court. Good morning, Your Honors. Jeff Kinstra on behalf of the United States. Beginning with the defendant's objections to the pattern and grouping enhancements, at the outset, the defendant waives his objection here by expressly telling the district court that these 2 enhancements themselves were correct. This is really the clearest category of waiver that exists, because this isn't a case of inaction or silence on the defendant's part. It's not a case of acquiescence or even a rote response of no objection to a broad inquiry. Here at the sentencing hearing, defense counsel specifically addressed these very enhancements, and in doing so told the district court that they are both correct. Defense counsel told the district court on page 3 of the sentencing transcript that the counts are not able to group. She also said that the defendant receives a 3-level enhancement under the grouping rules, plus a 5-level enhancement for the pattern enhancements, and then she said that that constitutes a correct application of the guidelines. At that point, the district court, recognizing that counsel was conceding her point, asked if this was actually a 3553A argument that she's making, and counsel agreed, effectively then withdrawing her argument. Now, the defendant notes that the defendant had previously objected to the pattern enhancements. Now, that pertained only to the pattern enhancements, not the grouping rules. But that really just reinforces the case for waiver here, because it shows that counsel was aware of this enhancement, that she considered objecting and initially did object, but then made an intentional choice to withdraw that objection. And of course, an intentional choice is what is central to the waiver analysis. And so when you have an instance like that where defense counsel is explicitly telling the district court that this is correct and affirmatively advancing that position, the defendant waives any contrary argument on appeal. Now, of course, at that point, any inquiry into strategy is unnecessary, but there was a strategic reason here, because the counsel's approach to sentencing was to get the district court to just disregard the guidelines range altogether, and instead focus on the much lower statutory sentence range, because no matter what, the guidelines range was going to be much higher than the range that the defendant was seeking. And so by just disregarding the guideline range, that helped the defendant's arguments that the court should instead look to the statutory range. And on top of that, counsel used her agreement to the 3-level pattern enhancement as leverage and as the premise for her arguments that the court should instead back out the entire 5-level pattern enhancement. So she agreed to the grouping and argued that the court should account for that combination by backing out the entire 5 levels instead of just 3 levels, and the court did that. It was a successful strategy because the court agreed with both of those arguments. The court disregarded the guidelines. It looked instead to the much shorter statutory sentencing ranges. It also said that the guidelines, it accounted for the combination of the 3 levels under the grouping rules plus the 5-level pattern enhancement by subtracting out the whole 5 levels for the pattern enhancement. It said that the sentence it imposed was within the middle of that range. So in a circumstance like this, strategy is not necessary, but it was present here as well. So this court need not even go through the analysis of plain error. On the merits, of course, it's only plain error because the defendant never made the grouping argument that he's making on appeal, and he can't satisfy any of the four prongs there for a number of reasons. The first is that his subsection B argument is raised for the first time in his reply brief, so it's waived for that reason. All that's before the court then is the subsection C argument, and his fundamental point there is that he should receive a lower guideline range for committing and being convicted of an additional offense, which is exactly contrary to how the guidelines say that their grouping rules should be applied.
It would be unusual, granted. What's wrong technically, though, with the language of 3D 1.2 B and C applying here?
So B cannot apply because the guideline applies only when there are multiple acts that cause the same composite harm. As courts have recognized, when there are multiple instances of sexual abuse and sexual exploitation, each of those instances inflicts a distinct harm on the victim.
So I'm looking at B. When
Right.
counts involve the same victim
Correct.
and two or more acts or transactions connected by a common criminal objective or constituting part of a common scheme or plan.
That
Sure looks like that fits here.
the application note specifically says that that applies only in the instance where the multiple acts inflict the same composite harm on the victim. And so it gives examples of, I think the one given in B is where there are different robberies. There's an example elsewhere in the application notes about different instances of rape. And so the courts recognize that in those examples, each instance of that sort of offense inflicts its own harm on the victim, and therefore grouping is not proper on that basis.
Okay. Since I'm going to just think out loud for a minute, because we've got one sexual encounter between the defendant and this victim,
That's correct.
and then we have the pictures.
Correct.
Pictures we tend to group together, right? For a lot of sentencing purposes.
Certainly for production, or for possession, receipt, not for production.
Okay.
For production, the defendant is causing the victim to engage in sexually explicit conduct and to take.
So if the defendant takes 5 pictures within 5 seconds, that's 5 separate harms, no grouping allowed.
So that would be a rare case where grouping may be appropriate for production. What courts have said there is when you have multiple images taken of essentially an uninterrupted sequence of acts, that grouping may be appropriate under B, but that's not the case here because the images themselves were separated by over 12 hours. The defendant made his request for those images over 48 hours apart. The images themselves depicted different types of sexually explicit conduct and involved intervening conduct by the victim. And so these were 2 different instances of sexually explicit conduct that the defendant caused the victim to engage in. And so grouping would not be appropriate under B. As to C, again, the guidelines of subsection C applies only when the conduct is in fact treated as a specific offense characteristic to another count. And here essentially we have a case where, if a tree falls in a forest and no one's there to hear it, does it actually make a noise? Here, nominally, the 5-level pattern enhancement applied to count 2, but it had absolutely no effect and was not actually treated as a specific offense characteristic in that circumstance. That's essentially what this court said in Burke, where it held that the grouping was not appropriate, where the enhancement in question did not actually affect the grouping or did not actually affect the analysis. And here, it's really a more perverse outcome that the defendant is seeking because he's arguing that he should receive a lower guideline range for committing and being convicted of this additional offense. On top of that, as Your Honor has recognized, of course, the government agrees that the count 4 should have cross-referenced 2G2.1. At that point, there is no pattern enhancement at all. The entire premise for the defendant's argument falls away. And certainly the government did not raise that argument itself in the district court, but the defendant did not raise his arguments either. And so it goes both ways there. To briefly touch on the defendant's other arguments, the sexual contact enhancement was proper. The undisputed conduct described in the pre-sentence report clearly satisfies the requirements in the provision that the offense involved a sexual act or sexual contact. Now, the defendant latches on to the use of the word sex act in the pre-sentence report, but the pre-sentence report didn't purport to use either of the terms of art in the guideline. It simply described the conduct itself. That conduct satisfies the provision. As to the defendant's claim that the court relied on inaccurate information, again, the government's position there is that the defendant waived his objection because he made a choice not to contest the harm the victim suffered because defense counsel well knew that the government statement was accurate as it was. Defense counsel made clear through her statements at sentencing that she knew that she was very familiar with the discovery and the victim's condition as reflected in those materials. In fact, she herself made arguments outside of the record based on her review of those materials. So she knew what they reflected about the victim's status. And with that knowledge, she chose to address that point by the government only by arguing about the defendant's proportionate share of responsibility for the victim's suffering without suggesting any disagreement at all with what that suffering entailed. And of course, the reasons for that are obvious. The defendant is seeking lenience here for his acceptance of responsibility. The least advantageous thing he could do would be to put more information before the court about the suffering that the victim endured, as well as to jeopardize his acceptance by contesting facts he knew to be true. Regardless, the defendant can't show any reliance on this information because he relies purely on statements by the government, not anything the court said. Everything the court said here was fully supported by the record and, as relevant here, by defense counsel's own statements. The defendant refers to the district court's reference to how an offense like the defendant's can contribute to and compound all the stresses the victim faced. Defense counsel said exactly that. She said the defendant is certainly part of what the victim is suffering right now. She also said that the defendant accepts his role, or responsibility for his role in that, and therefore that supported the district court's statements. Unless your auditors have any further questions, we'd ask this court to affirm.
Thank you, counsel.
Thank you.
The case is taken under advisement, and Mr. Merrill, we thank you for your willingness to accept the appointment in this case.
Thank you, Your Honor.
We're now ready for the sixth and last case of the day, Dubie against the Department of Homeland Security. Mr. Wasden.
Thank you. I think it's still the morning, so good morning, Your Honor. May it please the court, my name is John Wasden. I'm representing the plaintiffs in this case. From the outset, I just want to highlight, obviously immigration is a hot button issue right now. But this is not a Republican issue, this is not a MAGA issue, this is not a Democrat issue. This is a systemic issue with an agency that's somewhat gone amok and gone awry. So the ultimate question here is, can DHS evade its APA responsibilities and its own regulatory responsibilities in adjudication by making decisions in secret and waiting for people to leave the country and alerting CBP that there's been a decision made against them? Can they hide behind expedited removal and avoid their other legal responsibilities? The government, in their brief, cites Pac v. Biden and saying, if you can't divorce these issues, then they're related to each other and they're covered by the jurisdictional stripping provisions. But here you can divorce the issues. And the timeline of events here shows that, as well as the statements that were taken, the I-831s that were taken, especially for...
In what way can you avoid this statute, given its language? I understand your argument that we aren't attacking the exclusion at the border, we're attacking the reason for that exclusion. But every exclusion has a reason. If you say, well, we can go ahead and attack the reason, the statute just crumbles into dust. It would never apply at all.
So, Your Honor, if you take it a step further, though, let's just apply a real-world hypothetical. If you're an Indian national waiting for an immigrant visa, your green card, you have a 20-year wait from the time that it's approved. You can stay in the country as long as you have an initial approved H-1B visa that you got in a lottery. You could be days away from getting your green card, coming back into the country, and CBP could say, hey, your initial H-1B visa has been revoked. You can't stay in the country.
I understand that the world is full of injustices and unfortunate events. I'm asking you about a statute.
So I guess it's a question of which statute takes priority. Does the APA that requires certain decisions...
The first thing any court has to assure itself of is subject matter jurisdiction. We have a statute limiting subject matter jurisdiction. The Administrative Procedure Act says that it drops out when some other statute precludes review. That's section 701A1, which I notice your brief doesn't even mention, right? So we are driven to discuss the statute precluding review. And we still have my question, which you have not addressed.
If we go with that interpretation, Your Honor, there is no process that the government has to follow in immigration. Things that would ordinarily be challengeable in court, petition for judicial review, could all be avoided on the government side if all they have to do is make a secret determination and wait for you to leave the country and come back.
Yeah, you're not addressing the language of the statute or its interpretation either in this circuit, in O'Day, or elsewhere. I completely understand your argument that government should not be allowed to make secret decisions. But the first question is jurisdiction.
So I guess it's a question of what does related to mean? And here I would say related to cannot mean things that happened long before the application for admission to the United States.
The visa revocation decision is the reason why your clients were turned away at the border.
So
the very reason is related to being turned away at the border.
So the visa revocation is not the issue that we're challenging, Your Honor. It's the fraud finding that imposes a lifelong penalty.
Which led to the visa revocation.
Again, if the lifelong penalty is not in play, CBP can do expedited removal and send them on their way, then you'd have to go back to the consulate and you would have to get a new visa. Or first you'd have to get a waiver of your inadmissibility for that 5-year span. But the permanent bar to admission to the United States is what they're challenging. They're not challenging the consequences or the impact of the removal order or the visa cancellation.
If they're not challenging it, how do they have standing?
They're challenging the fraud finding, Your Honor.
Yes, but if they are not challenging their being turned away at the border, how do they even have standing?
Because the fraud finding imposes a lifelong penalty, and it's its own administrative action, its own final agency action. It's a separate adjudication that takes place within each visa petition adjudication that happens within USCIS.
So we're back to your proposition that although you can't challenge the removal or non-admission order, you can challenge the reasons for it. And that's the question I'm asking. Since every order ultimately has reasons, what in your view is left for the operation of this statute?
So, Your Honor, if you come to the port of entry and you're questioned, their suspicion arises, and you get asked questions by CBP, and you provide information.
You get asked questions by what?
What's that?
You get asked questions by, you then use some initials.
Oh, Customs and Border.
If you could use real words, that would help us amateurs.
My apologies, Your Honor. So if CBP is to organically
If you could use real words.
My apologies.
I know that may be hard.
Habit. Customs and Border could make their own organic determination, and that would not be challengeable. That fraud finding would stick. But where they're going back in time and trying to adopt a USCIS decision that was made.
I don't get it. You can't challenge the reasons if somebody is being completely arbitrary and high-handed at the border, but you can challenge the reasons if they're not arbitrary and high-handed.
So
that seems perverse, doesn't it?
Welcome to my world in immigration law. But yes, I would say that Congress set that in place, that Customs and Border Patrol can be as arbitrary as they want to be at the border and turn you around. Now, Congress also said that, and the agencies have adopted this by regulation, that there's certain things they have to do before they make a decision. And one of those things is give you the adverse information that they intend to rely on, as well as give you an opportunity to respond. And those are the things that obviously were short-circuited or bypassed here. if you look at the 831s for Dubie and Gacy, you see that there is no knowingly false statement that is identified or specifically stated. And the reason for that is because there isn't one. So the way that OPT works is you are in school, post-completion OPT. You're in school, you file your application. You don't have a job offer yet, but you can file your application to get your employment authorization document. Then you graduate, and once you have your employment authorization document, that can take 6 months to adjudicate. Then you can seek employment, and then you can start working in the U.S. So at the time they make their representation to the government that they're seeking OPT, they don't know who their employer is going to be, and that's completely permissible under the rules. And what Customs and Border Patrol is saying is that just by merely being associated with one of these companies that is suspect to DHS, that qualifies as a false statement. And that clearly doesn't track with what the law in 1182A6CI says. The other issue is that it shows that it's not a Customs and Border Protection issue, is that Customs and Border have no authority, no regulatory overview of the OPT program. That is entirely a USCIS issue. And so any questioning that Customs and Border does is going to be based solely on information derived from USCIS. And again, that short circuits the whole opportunity to respond to adverse derogatory information.
So what's the category of cases that you think are reviewable?
So it would be cases where USCIS makes a decision, enters it into one of their databases that is shared with Customs and Border Protection. And then Customs and Border Protection acts on it.
Okay.
A decision made by Customs and Border Protection of their own deliberation, that would not be reviewable.
Thank you.
And I think that's consistent with O'Day, because in O'Day, you have somebody who's coming to the U.S. and being questioned at the port of entry, and Customs and Border Protection makes the fraud finding. Here, we have the fraud finding while they're actually in the United States. The plaintiffs are in the U.S., the fraud finding occurs, they leave the U.S. and only find out about it on their way back, which...
So if they'd left before the fraud finding was made, then there would be no review.
Well, there'd be no notice that they could give them because they'd be out of the country.
Okay. Thank you.
Yeah. And I'm out of time, Your Honor. Thank you.
Thank you, counsel. Mr. Press.
Good morning. May it please the court, counsel. We believe that this is actually a pretty straightforward case under two decisions of this court. One would be O'Day, which Judge Easterbrook you referenced, and the other would be Matushkina, which Judge Hamilton, I believe you authored for the court. Both of those cases involved an extremely similar fact pattern to what we have here, i.e. a foreign national going to O'Hare Airport. Not all of the foreign nationals involved in this case went to O'Hare. I think one of them went to Logan Airport in Boston. We argued for severance based on these separate transactions or occurrences. District Court did not agree with us there. But the bottom line is that in O'Day, Matushkina, and this case, we have foreign nationals coming back on a visa, coming into the United States on a visa. CBP interviews them at primary inspection, Customs and Border Protection interviews them at primary inspection, and then they see some information or they get information based off the feedback from the applicant for admission, and they bring them into secondary inspection. Then they start to have a more fulsome conversation. That is, Customs and Border Protection has a more fulsome conversation about the applicant's relationship or misrepresentations to either the consular officer or the USCIS or both. And fraud findings were made in all three of the cases, so O'Day, Matushkina, and here. In Matushkina, the clever argument that the plaintiff tried to use to get around consular non-reviewability was, I'm not attacking the visa denial, I'm attacking the underlying agency determination of inadmissibility. Very similar to what we have here. In O'Day, the argument was, I'm not attacking expedited removal because I was allowed to voluntarily depart. I'm only attacking the inadmissibility determination. Again, very similar to what we have here. There are antecedent determinations that were made, in this case by CBP. Plaintiff wants to allege that they were made by USCIS, but that is not true. If it was true, or if it were true, rather, there would be no need for CBP to do any follow-up interview. And there were interviews of these plaintiffs in secondary inspection. And the CBP officer found that he or she was being effectively lied to, or that there was misrepresentation. The exact same type of thing that was going on in O'Day, the exact same type of thing that was going on in Matushkina. When Mr. Wasden talks about some sort of lifelong ban, what he means by that is this information that the plaintiffs in this case were caught up with companies that were abusing the optional practical training program. And by abuse, I mean they were letting students come in and say that they worked or did work study for those companies, but they never actually did any work study. We understand that if these students were innocently caught up in that, that could be a problem. Customs and Border Protection did not believe their stories that was innocent. And Customs and Border Protection therefore entered orders of removal or expedited orders of removal for 4 of the 5 plaintiffs in this case. The other plaintiff, Mr. Gase, was allowed to voluntarily depart. He thereafter applied for a visa and was denied based off this exact same transaction or occurrence, extremely similar to the Matushkina case that this court decided about 8 years ago. Whichever way you cut it, if they're trying to attack a decision or an antecedent determination that occurred months or years prior to the final agency action that's actually involved in this case, there would be a standing problem, as Justice Easterbrook was alluding to. If you try to attack from the consular denial of a visa for Mr. Gase, one of the plaintiffs, you'd have consular non-reviewability, you'd run into Matushkina. If you try to attack the expedited removal order by saying, aha, I'm not attacking the order itself, I'm just attacking one of the reasons for the order, then you run into O'Day. And so each area that the plaintiff wants to, or the plaintiffs want to try to go through is impenetrable. We understand that this is not, that this seems abrupt, but that's why we, in our brief, we do cite to numerous cases where executive decisions at the border or at port of entries for exclusion, that is, to prevent someone from coming in to the United States who is a foreign national, those are unreviewable. And that's why Congress has sort of set up the statute to be that way. They got tired of exceptions being found to that general rule and made it crystal clear in 1252A1(2)(a). I understand that that's a unwieldy citation, and I apologize on behalf of the executive branch for constructing it that way. However, we don't write the statutes. We only try to enforce them and make sure that this court gets it right from our end. So the language in that, notwithstanding any other provision or law, statutory or non-statutory, including habeas corpus, although there are exceptions with habeas corpus, as the Supreme Court articulated in Thursigium and applied in Thursigium, we think that language is very clear, that the APA is not an end run, and in fact, decisions from this court have also stated that the APA is not going to be particularly helpful in immigration exclusion in the immigration exclusion context. I'm sorry. Unless there are any questions, we would ask that this court affirm the judgment below.
Mm-hmm. Thank you very much, counsel. Thank you. The case is taken under advisement, and the court will be in recess.